Let me tell you a story. Two smart business owners sign a contract. They shake hands, they celebrate. 6 months later, they are in a dispute. One says, "You promised exclusivity." The other says, "Show me where that's written." Silence. That silence, that's bad drafting. Welcome to the real world of contracts. Whether you are a law student, a practicing lawyer, or a business owner trying to protect yourself, this session is built for you. Hey everyone, today we are going through the contract drafting clauses, covering around 28 essential clauses. Basically, a contract is simply a legally enforceable promise, a document that tells everyone who must do what, by when, and what happens if they don't. Think of a contract like a building. It needs a strong foundation to be reliable. If the base is weak or incomplete, the entire agreement can fall apart. These first four clauses form the foundation of your contract. These clauses are title clause, date clause, parties, and recital clause. Clause 1, Title clause. Title is not just a name, it tells people what this clause is about or what kind of relationship they are entering. Don't just write agreement or contract. For example, exclusive supplier agreement clearly shows the type of relationship. A clear title avoids confusion from the very beginning. Clause 2, Date and effective date. There are actually two dates that matters in a contract. The signing date when you physically sign and the effective date when obligation actually kicks in. These can be the same and they can differ. For example, a contract signed on March 1st might have obligations starting from 1st April. Always define the effective date accurately. Details of the parties, that is clause 3. This is about legal precisions. You don't just write ABC company, you write the full legal name, the type of entity like private limited, LLP, etc., the registration number or CIN number, and the registered address. Then you give each party a short defined name like company or manufacturer, so you don't repeat the full name 50 times throughout the contract. Clause 4, Recital clause, also called as whereas clause. Recital tells the story. They explain the background. Who are these parties? What do they each do? Why are they entering this agreement? Recitals are not legally binding on their own, but courts do use them to understand the intent of the parties when interpreting disputes. So, right, clause 5, definition clause. How your words are defined determines how your contract survives a dispute. The definition clause and the interpretation clause are the grammar rulebook of it. Notice that these definition points to exact clauses or give a specific list. No vague language. Define every important words used in a contract. Example term means 3 year. This prevents future arguments. Interpretation clause address questions like if I say include, does that mean it's an exhaustive list? The answer is no. Or if I write his, does it covers all genders? The answer is yes. These micro clarification prevent disputes at the macro level. Clause 6, Parties' obligations. If recitals are the story, obligations are the plot. This is the heart of your contract. Who does what, by when, and to what standard? Let me show you the difference between a weak clause and a strong one. Weak clause is manufacturer will deliver product quickly. There is no time frame, no measurable standard, totally unenforceable. The strong one clause is manufacturer shall provide the product within 14 days of receiving the order invoice. This is specific, measurable, and court ready, fully court ready clause. Clause 7, Consideration, Mode of Payment, and Default. Money is what makes the contract enforceable in the real world, and yet payment clauses are often the most poorly drafted sections. Let me walk you through what a proper payment clause look like. Step by step payment mechanism. Step 1, Invoice raised by manufacturer upon dispatch of products. Step 2, Company pays within 14 days of receiving the invoice. Step 3, if late, 2% interest occurs from due date to actual payment date. Step 4, if there is repeated failure to make payment, it will be treated as an event of default and the manufacturer will have the right to terminate the agreement. Clause 8, Representations and Warranties. Think of this as the trust clause. Before the contract even starts, both parties are making formal statements about who they are and what authority they have. If any of these turn out to be false, it's not just a breach of contract. It can be a case of misrepresentation, which carries separate legal consequences. Here, each party confirmed that they has legal authority and all required approvals to sign the contract. It also confirmed that it is properly incorporated and legally valid under Indian law, that it is not restricted from entering into this agreement, and that signing this contract does not violate any other agreement or any applicable law.